Hello, welcome to the best friend of Papoos who are about to fail their exams and to whom I become the harbinger of hope. You have your exam tomorrow morning, you have not touched your books. This is the video that will help you pass. Today, in the subject Labor Laws, Industrial Disputes Act 1947, we are going to talk about court or courts of inquiry as spoken about in section 6. A lot of Papoos get confused with the word inquiry. So I was taking this lecture about courts of inquiry. Courts of inquiry, INQUIRY, and two Papoos tell me, sir, it's not I, it's E. So listen to me good, okay? It's not E, it's I. What's the difference between inquiry which starts with an E and inquiry which starts with an I? They sound the same. What's the big difference? There is a big difference. You know, inquiry which starts with an E, it goes like this. You know, where is that hotel? Where is that restaurant? Do they give non-veg in that restaurant? Do they give vegetarian? कौन सी पिक्चर निकली है? सलमान की एक्टिंग कैसी है? That is E inquiry. I inquiry, I for investigation. कल रात को क्या कर रहे थे? कितने बजे घर पहुँचे? When your papa asks you, that is called I inquiry. When your principal asks you, it's I inquiry. So when it is investigation, it's I. When it's time pass, it's E. Okay? So we are talking about investigation. Courts of inquiry with an I as dealt with in section 6. Okay, here it goes. The appropriate government. Now, why do they keep saying appropriate government? Appropriate government. What's the meaning of appropriate government? Does it mean अच्छे लोग, जो सीधे साधे government? What is appropriate? Appropriate means उचित. It means respective. It could be central government or it could be state government, depending on the subject, depending on the nature of the dispute or the geography of the dispute. So the appropriate government may constitute a court of inquiry for inquiring into any matter appearing to be connected with or relevant to an industrial dispute by notification in the official gazette. Appropriate government can appoint a court of inquiry for any matter connected to or relevant to an industrial dispute. A court of inquiry may consist of one independent person or such number of independent persons as the government may deem fit. It could be a one-man committee, it could be a one-man court of inquiry, or the appropriate government may feel that this dispute requires more than one members. The only difference is, if there is more than one member, then one of them has to act as a chairman. Okay? So if there are two or more members, one of them will be appointed as a chairman. A court having, okay, I'm not going to go into this. It is the duty of the court to inquire into the matters referred to it and complete it within a period of 6 months from the commencement of inquiry. That's all. That's the last point. Court of inquiry set up by appropriate government can have one member independent person or can have more than one. If there are more than one of them acts as a chairman. They will complete their inquiry procedures within 6 months of the reference of the dispute. That's about it. That's section 6. If you write this much, there is not one examiner in the world who can fail our Papu. You're going to pass, at least in this question. You're going to come out with flying colors. Thank you very much for watching this video and saving your own reputation. See you soon. Bye-bye.